My brother Kirago, I have a message for you.
Well done. President, you make us proud. This guy brings us as one, and that is what we've always wanted. Yeah. And when you are near this man, he has lots of wisdom, tons of wisdom.
Unamsikia eh?
Of the country, and the live pictures on your screen is in Nyeri County, where residents and supporters of Dr. William Ruto celebrating moments after the Supreme Court upheld his win. And those are just some of the celebrations. Residents and supporters of William Ruto celebrating following that decision by the court, the Supreme Court, to uphold the win of Dr. William Ruto, and the court has declared that Dr. William Ruto was validly elected as the president, the 5th president of this country. And also we are getting reactions from different leaders. What you're seeing on your screen is some of the leaders, Betty Minor right there speaking. Let's just listen in to what they're saying.
Kenya, Excellency Dr. William Samoei Ruto, we thank God for you. We thank God that He has allowed you to reign over this nation for the next 5 years. And we want to thank God also for the Supreme Court Justice and the CJ for the unanimous decision. It makes it easier for the Kenyans to move on. And we want to say to all Kenyans that Kenya Kwanza government will not be just for the Kenya Kwanza supporters. It is a government for all the Kenyans. So do not feel left out as a Kenyan. Our doors are open. You belong here. We pray that there will be peace from now going forward, and don't feel as though you are not part of the incoming government. You are part of the Kenya Kwanza government. If you are Kenyan, we love you, we want you in, and we want to work together with everybody. We thank the judiciary led by the CJ for the great work they have done. They have done these proceedings in a very excellent, ethical and professional manner. The lawyers have conducted themselves very well, and we know that the democracy space in Kenya is growing, and together as a nation we can develop. Together as a nation we can concentrate on the issues that are affecting mwananchi. So it will be bottom-up economy for everybody. It will be a new season for everyone, and we believe we will grow together. Asanteni, God bless you. We will have our council say a word. Gatia, thank you. Gatia advocate, say something.
Yes, habari yenu. Yes, the client, the president-elect, will be making a statement later. Mine is just to say it's been a very, very engaging period, and we are thankful it has now ended. The time for court cases has ended. The time to assemble a new team has now started. We now move forward as one country and as one people. Asanteni sana.
So you will receive the statement from the President. Thank you. His Excellency Dr. William Samoei Ruto. Thank you.
So the statement from the legal team representing President-elect William Samoei Arap Ruto, and of course expressing gratitude for the decision from the 7-judge bench, unanimously upholding his victory in the August 9th polls. And a lot more reaction expected here from the legal teams. Now some statement from the legal team representing the former Prime Minister.
Well, are we all right? Yes. First and foremost, I want to thank our team of lawyers. As we know, we are a team of nearly 50 lawyers, and we have been working very hard for the last 14 days, this being the final day. Secondly, we want to thank our clients, the petitioner number 1, Raila Amolo Odinga, petitioner number 2, Martha Karua, and other eminent persons in this team, including Senior Counsel Stephen Kalonzo Musyoka, for having their trust and confidence in this team of lawyers to prosecute their case in petition number 5, which has been consolidated with other petitions, and put their case before the Supreme Court. I want to say without a fear of contradiction that we do not agree with the decision of the Supreme Court. Like Al Gore, I will say we accept the decision, but we do not agree with it. And I'm saying this as a seasoned practitioner that courts sometimes make mistakes which have to be corrected over time. Courts make political decisions. As you know, in the United States of America, there has been a long-standing case that has been held as universal truth of jurisprudence involving women's rights, Roe versus Wade. It took them 50 years to overturn that case because of a Republican Congress and a Republican president and a Supreme Court that was basically appointed by Republicans. And therefore, I want to say, yes, in accordance with the law, we got to accept this decision as the law of the land. But I think it is a very ideological decision. I think there are a lot of what was said in the judgment, and we'll have time when that judgment comes out, to put out a critique. But all it means is that in our jurisprudence, the petitioners will always have a big burden to carry when you have an electoral commission which is not open and transparent. The best way for this court to have made a decision was with the servers to be fully opened and all the election materials be placed before the court, as would happen in a case where justice has to be rendered. As you know, and I am saying this again without fear of contradiction, we wanted a comprehensive audit of not only the technology that was applied by the Electoral Commission, but we wanted a proper audit. Although time was of the essence, but I think we had sufficient time to carry out a proper audit, including looking at the issue of the foreign intruders, the Venezuelans, which you'd notice the court avoided in making any comment about those intrusions and invasions of the system, the technology, the IT structure. That again, the court did not refer to, but probably in the judgment, the recent judgment that is coming on the 21st, they will say something about it. And therefore, I want to end by saying the rule of law should prevail. The court normally has the last word in making a statement as to what is the law of the land. But as citizens who are sovereign, we're entitled to disagree, and disagree very vehemently. I think the court, in conducting the proceedings during the hearing, I think they were patient. They listened to us. It is only the outcome that we do not agree with. Finally, I think our clients, the two petitioners, Raila Amolo Odinga and Martha Karua, may be addressing another press conference, but we are happy to talk to you on this issue.
A watertight case, but we saw them talking about forgeries and wild goose chase. Did that surprise you?
No, I mean forgeries. When the DCI, the Director of Criminal Investigations, what we put before the court, a lot of it was from an agency of government. I didn't see them talking about similar incidents in matters concerning the Independent Electoral and Boundaries Commission. That's why I was saying it was a little ideological. They were looking for things on which to destroy our case, but similarly not taking sufficient time to look at what happened on the other side. And that will be another story for another day.
Would you admit you might not have been well prepared for this case?
We were very well prepared. I think compared to 2017, we were a lot more well prepared.
What would be the 2 or 3 points of mistake that you say the court might have made mistake on that?
In 50% plus 1, I think they were ideological. We are using the baseline of total registered voters in the land as against those who turned out to vote. If you read any legal material on what should be a turnout, including the Black's Law Dictionary, turnout is normally based on the registered members in a country as against those who turn out to vote. So there are so many other examples we can take up.
Are you still confident you lost on all grounds?
Yeah?
On all the key 8 issues you lost?
The issues that the court formulated, but we're quite happy to live with it and talk about it another time. Philip, you would want to say something?
Just on the idea that we lost on all 8-9 points, we find it incredible that that could be the holding of the court. In more than several of those cases, we had overwhelming evidence. As my senior counsel, Mr. Orengo says, the servers were not opened. The involvement of the Venezuelans for a full month before, half a month before the elections and up to the 16th of August was not explained. No, it wasn't even offered. We perhaps are a little distressed on the over-reliance of a registrar's report that has no input from us. That report was completely silent on the failure to open the servers. The servers, we repeat, the servers have all the answers. The exact role, we provided evidence that the Venezuelans were downloading documents, creating documents, and generating documents. None of that was touched. But as my colleague says, we hope they'll address all this in the final judgment. As somebody has said, it's incredible that we could lose on all points and they could win on all points. But as Senior has explained, it's probably the ideological aspect of this judgment.
Are you still confident on the 21st it will be a different ruling?
No. They have tied their hands. They can't get out of it. They have given their final decision. It's now a question of them finding the reasons for those findings and justifying them. It's not always easy, but I think they have some time to do it.
The other thing that I found a little bit disturbing is the presentation of the Form 34A by somebody I really respect as an advocate. It was described as hot hair, but you could see when that evidence was being adduced before the court, how engaged even the justices were. So I found it rather odd for them to, it was a document coming from the Electoral Commission. I found it very, very disturbing.
If I may explain a little further on that point made by Julie Soweto in the petition, that gentleman, Camargo's name was not supposed to be on Form 34A. If at all he was involved in this election, he was involved on the technology side. So to find it anywhere near a Form 34A raised more questions than answers. There was silence. And of course, on the issue of the famous 34A that Julie was describing, it was found to have been signed by the agents of UDA and UDM on the 7th, which is before the elections. No mention was made of that. So many things, many questions, perhaps more questions than answers, but it is the decision of the court. They have to live with it just as we have. Is that all? Thank you.
Of course, that is Philip Murgor. Philip Murgor was part and parcel of the council that were representing the first and the second petitioner, and with James Orengo, who was the lead counsel of the first and second petitioner. The first and second petitioner being Raila Odinga and Martha Karua. They were the main petitioners in the Supreme Court presidential petition of the year 2022. And of course, it is in the public domain that President-elect William Ruto is officially the 5th President of the Republic of Kenya. Will be taking over from the 13th of September when he will be sworn in as the 5th President, and also Deputy President-elect Rigathi Gachagua will be the second presidential, or rather the second Deputy President of the Republic of Kenya. It is the first time that someone has actually attempted to get the presidential election, and actually he has won. And it is the first time that a first-time member of parliament has actually attempted to be a running mate to one of the candidates, and has actually become the second deputy president of the Republic of Kenya. Issues argued there, and the final orders issued by the court, it was a unanimous decision that the presidential petition filed before it in 2022, it has actually been dismissed, and the petition, everyone to bear the cost Those were the orders that were issued by the Chief Justice Martha Koome. This is the second time that the court, this is the third time actually, that the court is upholding presidential election. The first being in 2013 by the Chief Justice then, Willie Mutunga, and the second being in 2017, the second, or rather the repeat presidential election that was upheld by David Maraga after the repeat election on 26th of October 2017. And for the third time, the new Chief Justice, who is barely an year in office, has actually taken over, or rather has actually upheld another election. That is the election of the Deputy President William Ruto as now the fifth president. I'm joined by my colleague Muremi Mwangi. Of course, Muremi Mwangi, you have been following keenly what has been happening. 9 issues that were to be determined by the court. And from the 9 issues, if I'm not wrong, all of them, the respondents seems to have carried the day, and I've actually heard Philip Murgor say that it wouldn't have been possible that they were wrong on all the issues. What's your take from how we have actually seen from this?
Well, speaking to the legal team representing the former Prime Minister in this particular petition, part of their concern, of course, is what you're saying, that unanimously they have lost on all 8 substantive issues, and therefore, as a matter of default from the 8 on issue number 9, which was the reliefs and the orders that they had sought, they've been all rejected across the 8 issues. And therefore, what they are saying is they are waiting for the substantive judgment, which is expected in 21 days, and it's from that particular judgment that a proper conversation within the legal team in terms of the analysis of the court's determination of the issues is going to be sought. But beyond that, there is also expected a separate communication from the Azimio la Umoja presidential candidate and his running mate, Martha Karua, because they are saying these being the petitioners, they hold the final communication on the political direction of the coalition heading forward. But from a legal perspective, speaking to Senior Counsel James Orengo and the rest of the legal team, they are saying they do not agree with the decision, but they respect it as a matter of principle, and they are giving some sort of analogy or comparison with a separate set of law which was unchallenged, was challenged perpetually but not overturned in the United States, and they are saying that happened for 50 years. So they are saying the Kenyan Supreme Court does not operate in isolation. They do not agree with the decision. However, they respect it, and it will be a foundation for future conversations on electoral reforms in Kenya.
Right, and talking about, before we hand over, talking about matters to do with politics, this is a very, it's going to go into history because, of course, Raila Odinga, 77 years old, I don't really think maybe he'll try out again in 2027. Again, William Ruto, for the first time, a deputy president or a vice president is attempting the top position and actually has managed to capture it. And again, one-term member of parliament has been the running mate and have actually now is the second in command. I think in matters history, what would you say about these happenings that have just happened in the 2022 election?
Well, in politics, they say nothing happens by accident, and assuming it even happens by accident, it will always be presumed to have been planned to happen that way. And in any case, there was expected an outcome in this election. But what will be interesting to watch, actually, is the progression beyond this, both for the Kenya Kwanza coalition led by the president-elect, as well as the Azimio la Umoja that now firmly assumes the role of the official opposition in parliament. We know that President Uhuru Kenyatta has gazetted Thursday as the day for the first sitting for the National Assembly and the Senate, and we expect some sort of direction from the former Prime Minister when he speaks later today in his reaction to this judgment now, because much of the spotlight and attention goes into preparations for the swearing in of President-elect William Ruto as the 5th President of the Republic of Kenya, and Rigathi Gachagua as the second Deputy President under the 2010 Constitution. Therefore, much of the spotlight now shifts to the work of oversight to this government that is coming in here. And one of the critical litmus tests, of course, will be the unity of the opposition, given the numbers that the Kenya Kwanza coalition has been able to marshal, and the fact that quite a huge chunk of the numbers from Azimio have given indication that might want to go to the side of government. And therefore, therein comes the critical test for the Odinga side as we await the comprehensive version of the judgment from the Supreme Court in 21 days.
And finally, there are some terms that were used by the Chief Justice, like the hot air, when referring to the evidence that was put across by Julie Soweto as the counsel. And yes, and of course, this kind of does it mean maybe the counsel that was representing the petitioners did not anticipate that the court would have maybe moved with such kind of terms in their arguments?
Well, the legal team representing the former Prime Minister have just expressed their displeasure here about the selection of language that was used by the judges. But I also put a question to them regarding their state of preparedness for this particular petition. And they argue that they were very well prepared. And partly what takes them aback is that they lost on all the issues that the court had listed for determination. But of course, it now goes back to the bench of the 7 judges to demonstrate and illustrate to the country why certain evidence that was adduced before them is hot air or a wild goose chase. Now, that of course is going to come out in the comprehensive version of the judgment, and that's when we can authoritatively now find why they found certain sections of the evidence adduced by the petitioners to be hot air or a wild goose chase.
And our elections, of course, having had such kind of a law that if you lose, you have the opportunity to file a petition. Could we say that from the perspective of that, if you are dissatisfied, you can have the opportunity to file the case? Does it mean that our democracy has actually changed totally? And also, if I would use Raila Odinga, could we say that he has really helped to change the way our elections are conducted? Because we realize that even as they kept using examples of a petition, or rather a precedent set of a petition that was filed by Raila Odinga in matters to do with presidential election. Could we say that we are headed to the best democracy in Africa and maybe probably the world?
Well, perpetually you can say post-2013 heading up until now, there has been what you might call a gradual enrichment of our jurisprudence on matters of election law. And you know, the petitioner consistently has been Raila Odinga, save for one petition that followed the repeat election of the 26th of October 2017. But over and above that is the political context upon which the contest happened, the election itself, as well as the petition here. If you remember in 2017, in the build-up to his decision to go to the Supreme Court, there was an outright rejection of the results, punctuated with mass action, and he continuously said that it's not his time to accept and move on. And even at the point when he was filing the petition, he said, well, we're going to file the petition, but this time we won't accept and move on. But eventually the decision came. He rejected the call to go back to the repeat election with the same IEBC commission, and therefore boycotted the election. This time round, we saw him reject the outcome of the results, give a comprehensive statement and say he's going to pursue a recourse through the legal mechanisms. He came to the Supreme Court. The hearing has been quite peaceful, even within his traditional political basis. And here the statement coming from his legal team that they may not agree with the decision, but they respect it. And of course, you could say it has set some sort of stage in intonation in what we expect from him and his running mate when they address the country a bit later today. But it's also an interesting stage in terms of growth of this. If I take you back to 2017, when the Supreme Court nullified President Uhuru Kenyatta's re-election, Wafula Chebukati, as the commission chair, was quick enough to go back to the same Supreme Court, seek an advisory opinion on the election process. Because you remember the 2017 nullification was on the basis of the process itself, so that he knows the finality of the results. Is the result final at the constituency, the polling station, or the national tallying center? And an advisory was given. And that is the basis upon which he did what he did this time round. And of course, from the determination of the judges here, you would expect that in future elections, this also becomes a critical reference point for whatever electoral body that will be overseeing the future elections.
Right. Thank you. Thank you, Muremi Mwangi. We've been with Muremi Mwangi here looking at issues to do with the ruling that has just been rendered by the 7-judge bench, and maybe to just take you through some of the issues that have been tackled and what was the opinion, or rather the orders findings of the court. The first one being whether the technology deployed met the standards of integrity, security, and transparency. Of course, the 7-judge bench unanimously said that the petitioners could not show or prove that indeed there was the system, or rather the technology deployed by the commission did not meet those the set targets of security and matters to do with transparency. And of course, again, matters to do with interference. Also, it was dismissed that the respondents did not persuade the judges that indeed there was